contracts and sales out of the Barbri commercial outline. Last 11 pages. We're talking section 9, which is assignments and third-party rights. Assignment of rights and delegation of duties is part C of that section. The basic fact between the basic fact situation to be dealt with here is X enters into a valid contract with Y. This contract does not contemplate performance to or by a third party. Subsequently, one of the parties seeks to transfer her rights and or duties under the contract to a third party. Assignment of rights, part 1 of this section. The transfer of a right under a contract is called an assignment. The main issue regarding assignments are what rights may be assigned and what is necessary for an effective assignment. Is the assignment revocable or irrevocable? What are the rights and liabilities of the various parties? And what problems exist if there has been successive assignments of the same rights? There's our graph. Do we have promisor, promisee on there, or do we just have assigner, assignee? Wherever it says assigner, obligor is your promisor. Promisee, assignee is your promisee. No. We'll never figure this out. Alright, anyway. Here's your terminology. X and Y have a contract. Y assigns her rights under the contract to Z. Y is the assignor, and Z is the assignee, and X is the obligor. What rights may be assigned? 1. The general rule is generally all contractual rights may be assigned. However, several exceptions to the rule exist. Let's go over the exceptions. A. Assigned rights would substantially change obligor's duty. That's an exception to assignment of rights. B. Rights assigned would substantially alter the obligor's risk. C. Assignment of future rights. D. Assignment prohibited by law. E. Express contractual provision against assignment. E again. Partial assignments. F. Is the assignment revocable or irrevocable? Alright, we might still be under express contractual provision against assignment. Partial assignments. E again. Is the assignment revocable or irrevocable? And G. What are the rights and liabilities of the various parties? Alright, well, we're going to get through at least that before we quit. Nope, there's more. H. What problems exist if there have been successive assignments of the same rights? Boom, we're getting to that. What rights may be assigned? All contractual rights. However, there's several exceptions. Exceptions being that assigned rights would those being starting with A. Assigned rights would substantially change obligor's duty. If an assignment of rights would substantially change the obligor's duty, the assignment will be barred. In personal service contracts, 1. If the assignment of rights would result in the obligor having to perform personal services for someone other than the original obligee, the attempted assignment will be invalid. For the purposes of assignment, The test as to what constitutes personal services is whether the performance so involves the personality and personal characteristics of the obligor that it would be unfair to require the obligor to perform for a third person. Examples of personal services that cannot be assigned include those of a lawyer, physician, architect, or author. In contrast, repair and construction contracts usually are not considered to involve personal services, so a contractor may be required to perform his performance to an assignee. Requirements and output contracts 2 versus personal service contracts. Although at common law rights under requirements and output contracts were not assignable, under Article 2 they are assignable as long as the assignee does not disproportionately alter the contemplated quantity. Likewise, the buyer's duty to purchase goods under an output contract and the seller's duty to sell goods under a requirements contract can always be delegated unless they fall within the general restrictions on delegation listed to be infra because the other party's rights are not affected. B. Exception B. To rights that can't be assigned. Rights assigned would substantially alter the obligor's risk. So we were talking about the obligor's duty, and now we're talking about the obligor's risk being substantially changed. When the obligor's risk would be substantially altered by any attempted assignment, the assignment will fail. Why? Or, for example, Juan owns a summer home that is insured by Acme Insurance Company against loss due to fire. Juan sells the building to Lincoln, who intends to convert it into a restaurant. Juan may not, without the consent of Acme, assign his rights under the policy to Lincoln. Because a summer home changed to a restaurant is a big difference in the insurance company's risk. C. Assignment of future rights. The assignment of a right expected to arise under a contract of employment, not then existing, operates only as a promise to assign the right when it arises. For example, when the expected future contract is in fact entered into. Contrast this with future rights in existing contracts, which are generally assignable even though the right may not yet have vested. Assignment prohibited by law. The right may not be assigned if the assignment is prohibited by law. Such public policy against assignment may be embodied either in a statute or in case precedent. For example, many states have laws prohibiting or at least limiting wage assignments. So, we just went over assignment of future rights and assignments prohibited by law. If it's against public policy, example, wage assignments aren't allowed. E. Express contractual provision against rights assignments. 1. Assignment of the contract. Absent circumstances suggesting otherwise, a clause prohibiting the assignment of the contract will be construed as barring only the delegation of the assigner's duties. And this is covered in the Restatement Second of Contracts, Section 322. And it's also covered in the UCC 2-210-4. For example, Sam and Betty enter into a contract wherein Betty will purchase 100 books from Sam, a book collector, for $5,000. The contract provides that this contract shall not be assigned. Subsequently, Sam assigns to Charlie his right to receive the $5,000 from the contract. Sam has not breached the contract because he merely assigned his right to receive payment. He did not delegate his duty to deliver the books. Okay, so 2, under the express contractual provision against assignment. Assignment of rights under the contract. A clause prohibiting the assignment of contractual rights generally does not bar assignment, but merely gives the obligor the right to sue for breach if an assignment is made. See Restatement Second of Contracts 322. In other words, the assigner has the power but not the right to assign. A. Factors that make assignment ineffective. Notwithstanding, and this is A under 2, which is the assignment of rights under a contract. So, factors that make the assignment ineffective. Notwithstanding the general rule, if the clause provides that any attempt to assign will be void, assignment will be ineffective. For example, the assigner has neither the power nor the right to assign. Also, if the assignee has notice of the non-assignment clause, assignment will be ineffective. That's the assignee has notice of the non-assignment clause. It's ineffective. C, effective assignment, real party, and interest. Where's B? Oh God, I'm just, they kind of messed up their outline here. So we skipped B, we went to effective assignment, real parties and interest. The effect of an assignment is to establish privity of contract between the obligor and the assignee while extinguishing privity between the obligor and the assignor. The assignee then replaces the assignor as the real party in interest, and she alone is entitled to performance under the contract. And D, what is necessary for an effective assignment? We have 1, 2, 3, and 4. 1, requirement of writing. 2, requirement of adequate description. 3, requirement of present words of assignment. And 4, no requirement of consideration. The requirement of writing. 1, a writing is usually not required to have an effective assignment, so an oral assignment is generally effective. However, there are situations where an assignment must be in writing, and that's wage assignments, since they're mostly prohibited by public policy, assignments of an interest in land, and assignments intended as security interests under Article 9 of the UCC. 2, the requirement of adequate description. The right being assigned must be adequately described. That's easy enough. 3, requirement of present words of assignment. The assigner must also manifest an intent to transfer his rights under the contract completely and immediately to the assignee. Whether such intent is present will be determined by looking to the terms of the transfer itself. For example, the test is objective, not subjective. It is not necessary to use the word assign, and any generally accepted words of transfer will suffice. For example, convey, sell, transfer, etc. Excuse me. 4, no requirement of consideration. Consideration is not required. A gratuitous assignment is effective. Note, it is important to remember, however, that even though neither a writing nor consideration is generally required, the lack thereof will affect revocability. Okay. Consideration is not required. A gratuitous assignment is effective. Note, it is important to remember, however, that even though neither a writing nor consideration is generally required, a lack thereof will affect revocability. Now, we're going to E, partial assignments. Contract rights may be transferred to one assignee or split up and transferred to 2 or more. Similarly, the assigner may transfer some rights under the contract and retain others. F, is the assignment revocable or irrevocable? When, if ever, do the rights of the assignee vest so that the assignment becomes irrevocable? Assignments are divided into 2 categories: assignments for value and gratuitous assignments. 1, assignments for value are irrevocable. The assignment is for value if it is 1, done for consideration or ruminant; 2, taken as security or for or payment of a pre-existing debt, and agreements for value cannot be revoked. Gratuitous assignments are revocable. 2, this is on page 123. An assignment not for value, i.e. a gratuitous assignment, is generally revocable. You have under A, exceptions to rule of revocability, 1 through 4. 1, performance of obligor. 2, delivery of token shoes, which is also referred to as tangible claim. 3, assignment of simple shoes in writing. And 4, estoppel. So, in certain situations, however, a gratuitous assignment will be held irrevocable. 1 is the performance by the obligor. If the obligor has already performed, the assignment will be irrevocable. 2, delivery of token shoes. Chose. If a token choose tangible claim involving the rights to be assigned, example, stock certificates, savings account, passbook, etc., has been delivered, the assignment will be revocable. Assignment of simple chose in writing. If the assignment involves a simple chose, i.e., an intangible claim not embodied in any token, or the great majority of ordinary contract rights, setting it forth in a writing may make the assignment irrevocable. And lastly, the exception to rule of irrevocability is estoppel. The theory of estoppel may prevent the assigner from revoking a gratuitous assignment if I, Romanet 1, the assigner should reasonably foresee that the assignee will change her position in reliance on the assignment, and Romanet 2, such detrimental reliance does in fact occur. So the position is changed as a result of relying on the gratuitous assignment. Methods of revocation. A gratuitous revocable assignment may be terminated in a number of ways. This is death of the assigner, 1. 2. Bankruptcy of the assigner, 3. Notice of revocation communicated by the assigner to either the assignee or the obligor. 4. The assigner takes performance directly from the obligor. Or 5. Subsequent assignment of the same right by the assignor to another. The effect of the revocation. Once an assignment is revoked, the privity between the assigner and the obligor is restored, and the assigner is once again the real party in interest. Effective and irrevocable assignment. One should note that the term irrevocable is applied to an assignment may be misleading. The effect of such a revocability is to remove from the assigner the right to revoke or make a subsequent assignment of the same right to a third party. However, in many situations, even though the assigner no longer has the right, he still has the power to do so. He would, of course, be liable for a breach of contract. Exception. An exception exists for assignments accompanied by delivery of a token chose. In this case, the assigner loses both the right and the power to revoke or further assign. G. What are the rights and liabilities of the various parties? Assignee versus obligor. Number 1. As the assignee is the real party in interest, she may enforce her rights against the obligor directly. A. What defenses does the obligor have against the assignee? An assignee's rights against the obligor may be subject to any defenses that the obligor had against the assignor. This rule is similar to the rule discussed supra for promisors who are being sued by third-party beneficiaries. We're given an example. Opie, a mechanic, enters into a contract to purchase a car from Andy for $2,000, payments to be made in 30 days. Opie then performs some repair work for Andy and bills Andy $200. Andy tells Opie to subtract the $200 from the $2,000 that Opie owes Andy. The following week, Andy assigns his right to collect from Opie to his landlord, Lori. If Lori brings suit against Opie to collect the entire $2,000, Opie can raise the $200 set off as a defense. One exception: personal defenses arising after assignment. 2 is going to be estoppel. So for this exception to the defenses that the obligor has against the assignee, which is personal defenses arising after assignment, we read, if the obligor's defense is unrelated to the contract itself, for example, it is a personal defense against the assignor, such as a set-off or counterclaim, the defense is not available against the assignee if it arose after the obligor had notice of the assignment. Some facts, as in the example in A above, same facts, that is, as in the example in A above, but Opie performed the work for Andy after Andy asked Opie to pay $2,000 due under the purchase agreement to Lori. Andy may not raise the set-off as a defense against Lori because it arose too late. So there's a test here for this exception. Is the defense inherent in the contract itself? For example, failure of consideration. Or is it a defense unrelated to the contract, comma, the right of which has been assigned. As to defenses inherent in the contract itself, these defenses are always available against the assignee because they came into existence when the contract was made. As the set-offs, counterclaims, and the like, such defenses are good against the assignee only if they came into existence before the obligor had notice or knowledge of the assignment. So, 2, this is another exception, I believe, to the defenses that the obligor has against the assignee. 2 is estoppel. The estoppel doctrine may operate to prevent the obligor from asserting a defense that might otherwise exist against the assigner. So, an example, Jim and Harold entered into a contract. Consequently, Harold sought to assign his rights under the contract to Zorba. Zorba inquired of Jim whether he had any defenses against Harold. Jim replied in the negative. Thereupon, Zorba paid Harold very valuable consideration for the assigned rights. Jim may be estopped to raise any defenses existing at the time of his statement to Zorba. Modification of the contract, which is B. B what? B under assignee versus obligor, which is within G, what are the rights and liabilities of the various parties. So, suppose that after the obligor has received notice of the assignment, the obligor and the assignor attempt to modify the contract. Will the modification affect the assignee's rights? 1. No effect on rights of assignee. Generally, such a modification of the contract will not affect the rights of the assignee. This is so even when the modification is undertaken in good faith. The UCC position 2. The UCC provides that such a modification of an assigned right to payment that has not yet been fully earned by performance is effective against the assignee if made in good faith. However, the modification will cause a breach of an assignment contract that prohibits such modifications. So the UCC has provided that a modification of assigned right to payment has not yet been fully earned by performance is effective against the assignee if made in good faith. However, the modification will cause a breach of an assignment contract that prohibits such modifications. And this is you can read more about that in the UCC section 9-405. Defenses of assigner not available. C. Again, talking about assignee versus obligor. What defenses does the obligor have against the assignee was A. Modification of the contract was B. And now in C, defenses of assignor not available. The obligor will not be able to raise by way of defense any defenses that the assigner might have against the assignee. Alright, so when we're talking about the assignee versus the assignor, because all in all we're trying to talk about who's got rights. Yes? I don't know if that's right. Can I trust this? This outline got like really confusing really fast. But we're 4 pages to the end, so let's just talk about the assigner's warranties in the assignee versus assignor section. In every assignment for value, the assignor impliedly warrants that Romanet 1, he has the right to make the assignment, i.e. the assigner has made no prior assignment of the right. Romanet 2, the right exists and is not subject to limitations or defenses other than those stated or apparent at the time of the assignment. And Romanet 3, he will do nothing to defeat or impair the assigned right. For example, he will not attempt a subsequent assignment. Okay, we have cited here restatement second of contracts, section 333. Breach of any of these warranties gives rise to cause of action. For example, if the assigner wrongfully exercises his power to revoke the irrevocable assignment, the assignee may proceed against him. Also, the assignee may seek to recover against the assignor if the obligor successfully asserts a defense she had against the assignor in the action by the assignee, thereby defeating the assigned right, provided the assignee has no notice of the defense at the time of the assignment. B, obligor incapable of performance, and C, rights of sub-assignees. So again, under assignee versus assignor, after we talk about the assignor's warranties, we now are talking about the obligor being obligor incapable of performance. The assigner will not be liable to the assignee if the obligor is incapable of performing, i.e. he is insolvent. And third, rights of sub-assignees against the assignor. Sub-assignees do not have any rights against the original assignor. The court reasons that there is no privity of contract. However, the assignee who sub-assigns becomes the assignor with respect to that assignment and can be held liable thereon. So 3 now, do third parties have any equities relating to assignment? For third parties if third parties have any equities in the subject matter of the assignment, the assignee will take subject to them if she has notice. She will not be subject to such equities if she is a bona fide purchaser without notice of the assigned interest. Not sure where this is coming from. Okay, this is the 3. Do the parties have any equities related to the assignment? What was the 2? Where's what? Estoppel? No. Okay. What was the 2? The 2 was probably a question. The 2 was... Okay, again, when we entered section C, we were talking about assignment of rights and delegation of duties. We had 1 in the assignment of rights. And we might very well still be in 1. The assignment of rights. Where's 2? 2 is delegation of duties. Boom. Okay. So 3. Do third parties have any equities relating to assignment? Okay. So this is, I think, outside or supposed to be outside of assignee versus assigner. So we can move on from that. We hope. And yet we're still returning back to H. H comes after third parties having any equities relating to assignment. Let's just get this out of the way. If third parties have any equities in the subject matter of the assignment, the assignee will take subject to them if she has notice. She will not be subject to such equities if she is a bona fide purchaser without notice of the assigned interest. So if third parties have any equities in the subject matter of the assignment, the assignee will take subject to them if she has notice. She will not be subject to such equities if she is a bona fide purchaser without notice of the assigned interest. Anyway, H again, what problems exist if there have been successive assignments of the same rights? The problem, X assigns to Y a right up to the payment of $500 owed him by Smith. Subsequently, X assigns the same right to Z. Who prevails, Y or Z? Revocable assignments. 1, and irrevocable assignments. If the first assignment made is revocable, a subsequent assignment will serve to revoke it, i.e. the subsequent assignee prevails. Now, in the irrevocable assignments, the first assignee has priority. The general rule is that if the assigner makes 2 assignments of the same right and the first assignment is irrevocable, the first assignee has priority. The exception is, in certain situations, a second assignee who pays value and takes without notice of the earlier irrevocable assignment will prevail. So, a second assignee who pays value and takes without notice of the earlier irrevocable assignment will prevail. So 1, 2, 3, 4, and 5. 1, judgment against obligor. 2, payment of the claim. 3, delivery of token shows. 4, novation. And 5, estoppel. Judgment against obligor. If the subsequent assignee gets the first judgment against the obligor, she will prevail. Payment of claim, number 2. If the later assignee gets first payment from the obligor on the assigned claim, her rates will be superior. Third, delivery of token shows. If the subsequent assignee gets the first delivery of a token shows from the assigner, she will prevail. Novation. The second assignee will prevail if she obtains a novation that supersedes the obligation running to the assignor in favor of the new one running to her. This assumes that the obligor had no right of the prior assignment at the time of the novation. Estoppel. 5. If the subsequent assignee is able to set up an estoppel against the first assignee, she will have priority. For example, the first assignee permits the assigner to retain a document that would indicate to a reasonable person that the assigner was sole owner of the right. Estoppel could, of course, operate the other way as well. Thus, if the subsequent assignee has actual knowledge of the earlier assignment, she will be estopped to assert her claim as against the earlier assignee, even though she would, under any of the other rules above, normally succeed. So 3, we're talking about the UCC rules. And this is another 3. 3 is what problems exist if there have been successive assignments of the same rights. So we know that the UCC rules are going to point us to section 9-322. Basically, the UCC has approached the successive assignments problem by imposing filing requirements. UCC 9-310 is where to look for filing requirements. If the filing provision is applicable to the transaction, generally the assignee who is the first to file will prevail. Now for delegation of duties, this is the second half of this section. When we began talking, section titled Assignment of Rights and Delegation of Duties. Now are the delegation of duties. So all that assignment of rights BS is over with. Under delegation of duties, a transfer of contractual duties is called a delegation. The main issues regarding delegations are what duties may be delegated. Romanet 2, how does one make a valid delegation? And Romanet 3, what are the rights and liabilities of the previous parties where there has been a valid delegation? You see terminology here. X and Y have a contract. Y delegates duties thereunder to Z. Z is the obligor because Y is the one with the duty to perform the obligation, and Y also is the delegator, sometimes called the delegant, because Y delegated the duty. Z is the delegate, sometimes called the delegatee, because Z is the one to whom the duty was delegated. X is called the obligee because X is the one for whom Y or Z is obligated to perform. So our professor does this a little different. He says that he positions the arrows the other direction, but not to be confused. Delegate, delegatee mean the same thing. Delegator and delegant mean the same thing. But that's going to be confusing. So here's a picture. I can hold it steady. What duties may be delegated? General rule. As a general rule, all contractual duties may be delegated to a third person. Exceptions. There are several exceptions to the general rule. Duties involving personal judgment and skill. If the duties involve personal judgment and skill, they may not be delegated. For example, a talent agency cannot delegate its duty to select performers for a certain show to some other agency. It is immaterial that the other agency may have better reputation and may have more performers under contract than the delegator. A court will not make such inquiries at all. Other exceptions, B, C, and D. B, special trust and delegator. C, change of obligee's expectancy, and D, contractual restriction on delegation. So B, the special trust in the delegator. Where a special trust has been reposed in the delegator, he may not delegate his duties, for example, relationship of attorney and client, physician and patient, etc. And C, change of obligee's expectancy. If performance by the delegate will materially change the obligee's expectancy under the contract, the duty may not be delegated. D, contractual restriction on delegation. If a contract restricts either party's right to delegate duties, such a provision will usually be given strict effect. C, what is necessary for effective delegation? In general, no special formalities are required to have a valid delegation. The delegation may be either written or oral. However, the delegator must manifest a present intention to make the delegation. There is no need that the word delegate be used. Any generally accepted words to transfer may be used. So that answers C, what is necessary for effective delegation. D, what are rights and liabilities of parties? So rights and liabilities of the obligee are as follows. The obligee must accept performance from the delegate of all duties that may be delegated. She need not accept performance from the delegate of those duties that may not be delegated. For the delegator will remain liable on his contract even if the delegate expressly assumes the duties. However, as between the delegator and the delegate, the delegation places the primary responsibility to perform on the delegate. The delegator becomes secondarily liable as a surety for the performance of the duty. Note that if an obligee expressly consents the transfer of duties, it could be construed as an offer of novation, see below, rather than delegation. So, delegate. The liability of the delegate turns largely on the question of whether there is a mere delegation or that plus an assumption of duty. So again, we're talking about rights and duties of delegates. Rights and assignees of the parties. I was just holding up whoever they are. Delegate. The liability of the delegate turns largely on the question of whether there is a mere delegation or that of an assumption of duty. So a delegation is being discussed, assumptions being discussed, and result when duties delegated with assignment of rights, I guess, which is a combination of both. So a delegation is the creation of a power in another to perform the delegator's contract duty. The non-delegating party to the contract, the obligee, cannot compel the delegate to perform as the latter has not promised to perform. Now, an assumption occurs when the delegate promises that she will perform the duty delegated, and the promise is supported by consideration or its equivalent. This creates a third-party beneficiary situation in which the non-delegating party to the contract can compel performance or bring suit for non-performance. For example, Tom promises Becky that he will paint her fence for $100. Tom then asks Huck if he would paint the fence for $50. If Tom provides Huck with all of the paint supplies needed, Huck agrees. Becky is a third-party beneficiary of the contract between Tom and Huck and may enforce Huck's promise to paint. Mark Twain. C. Does result when duties delegated with assignment of rights. What happens if a delegation of duties is made in connection with an assignment of rights under the same contract out of which the duties arise, but the delegate has nonetheless not expressly assumed the duties? The majority of courts, the restatement and the UCC hold that unless a contrary intention appears, words assigning the contract or all my rights under the contract are to be construed as including an assumption of the duties, i.e. they imply a promise by the assignee to assume the duties of the performance. Now, D, novation distinguished from other third-party situations. This is entirely different than assignments and delegations. So this is your novation, distinguished from other third-party situations. Note the difference between novation and the other third-party situations discussed above. Novation substitutes a new party for an original party to a contract. It requires the assent of all parties and completely releases the original party. The consent of the remaining party may be expressed or by implication of the acceptance of performance by the new party with knowledge that a novation is intended. Now, forget everything we just said about novation because we're moving on to power of person other than owner to transfer a good title to a purchaser. So, first we're going to discuss the word entrusting. This is all new to me, but it's the last page, so no biggie. Entrusting goods to a merchant who deals in goods of the kind gives him the power, but not the right, to transfer all rights of the entrustor to a buyer in the ordinary course of business. You want to see the UCC section 2-403. Entrusting includes both delivering goods to the merchant and leaving purchased goods with the merchant for later pickup or delivery. Buying in the ordinary course means buying in good faith from a person who deals in goods of the kind, without knowledge that the sale is in violation of the ownership rights of third parties. The examples that were given is Amy leaves her watch with jeweler for repairs. Jeweler sells the watch to Zoe, who does not know that jeweler has no right to sell. Zoe gets a good title against Amy. Amy's only remedy is to sue the jeweler for the damages. 2. Amy leaves her watch with jeweler for repairs. This is another example. Jeweler borrows money from the bank, giving specific items of inventory, including Amy's watch, as pledge collateral. Amy can recover the watch from the bank. The bank is not a buyer. So, 2 and 3 are the last parts underneath the power of person other than owner to transfer goods, good title to a purchaser. So, 2, voidable title concept. The UCC continues the pre-code concept of voidable title. See UCC 2-403. That is, if a sale is induced by fraud, the seller can rescind the sale and recover the goods from the fraudulent buyer. However, the defrauded seller may not recover the goods from a good faith purchaser for value who bought from the fraudulent buyer. The UCC specifies 4 particular situations in which the bona fide purchaser for value cuts off the rights of the true owner. In several of these instances, the result under pre-code law is changed. Under the UCC, the good faith purchaser for value cuts off the defrauded seller's rights, even though the seller was deceived as to the identity of the buyer. Ruminant 2, the delivery was in exchange for a check later dishonored. Ruminant 3, the sale was a cash sale. Or Ruminant 4, the fraudulent conduct of the buyer is punishable as larceny. The rights of a defrauded seller are cut off by both by a buyer and by a person who takes a security interest in the goods. And third, under the power of person other than owner to transfer a good title to a purchaser, is a thief generally cannot pass title. If a thief steals goods from a true owner and then sells them to a buyer, the thief is unable to pass title to the buyer because his title is void. The rationale: a seller can transfer only the title he has or has power to transfer. Therefore, even a good faith purchaser for value generally cannot cut off rights of a true owner if the seller's title was void. For example, thief stole a painting from owner and sold it to buyer. Later, owner discovered that buyer had her painting. Owner may recover the painting from buyer, even if buyer purchased the painting in good faith and for value. Now, an exception is a thief may pass title in limited circumstances, such as where the buyer has made accessions. Example, valuable improvements to the goods, or the true owner is stopped from asserting title. For example, if the true owner expressly or impliedly represented that the thief had title. And that's the end.